profit back so it can now redeploy it in other charitable uses, and now the Crow tribe will own its businesses outright, having used the private sector capital and the foundation capital when they needed it, as long as they needed it. But what's interesting is the Crow tribe happens to be in Montana. And you'll notice that Montana is one of the states scheduled to enact this law this year, but has not yet done so. The Crow tribe did, as a law it's passed. Montana happens to be the home state of Senator Max Baucus, who happens to be the chairman of the Senate Finance Committee, who has jurisdiction over the presumptive registration law that I just talked about. So it is no coincidence that there is an interesting community of interest building around L3Cs within the state of probably the most important person in getting this legislation done. I should tell you also that the Joint Committee on Tax, that is the tax experts of both the House and the Senate, U.S., have already joined together and reviewed the Presumptive Registration Act, and both have both sides of the Congress have concluded that this is a useful and productive tool for capital formation, especially in these times, I would say. Well, thank you. Daniel, are we taking questions now, or are we going to wait till after Jen?
However you want to do it.
However, does anybody have a question now, or otherwise I'm going to introduce Jen Walling. I'll take 2 questions, and then we really have to have our special honored guest here talk for a little while. Yeah, in the back.
I guess one of the requirements you said is there has to be a partnership. The L3C has to be a partnership with for-profit and not-for-profit, essentially, or I forget how it's written.
Yeah, that's right.
Now, does that then are they required to have a for-profit member, or can it be the foundation providing the base level of funding and then say bond financing coming in above?
Yes. It is not required. What I've given you is kind of what is expected to be the typical pattern. A foundation can come in both as a program-related investor, but also a plain old investor. It can also have an investment at a higher place in the food chain, which would be a mission-related investment rather than a program-related investment. So there, this can be shaped in any way you'd like it to be shaped. I should say further that a limited liability company under today's law, before L3C is enacted, can have a for-profit and a non-profit owner. There's nothing that prevents it. It's just the statute tracks the language of program-related investing, and therefore gives a higher degree of comfort to foundations that may want to participate. I'll take one other question. Yes, sir.
As an LLC, how does the oversight compare to nonprofit? So there's a new Form 990 and guidelines for executive compensation.
Yeah, none of the above.
Restrictions on that?
None of the above. This is a for-profit. The only issue that arose in opposition, I won't even call it opposition because it was in the state of Michigan to the L3C concept, and because their legislative research body was obliged to report back to the legislature on pros and cons. And they came up with one con. And the one con was, well, a nonprofit has to have 3 directors or trustees, and an L3C could have only 1 manager. Well, that's right, because an L3C is a for-profit business, and a for-profit corporation need have only 1 director, and a sole proprietor only has 1 owner. So this is a for-profit business. There are no 990 type requirements. The requirements are going to be tax reporting of, and LLCs, as you may know, have an election. They can either be taxed as a corporation or taxed as a partnership. These, my guess is, would in almost all cases be taxed as a partnership with flow-through consequences. So it would be a Form 1065, and then each member would receive a K-1, but no specialized reporting. Okay, I'll take questions again if you still have any after Jen speaks, but she'll probably answer all of your questions. I'd like to introduce Jen Walling. Jen is Senator Heather Staines' chief of staff. Senator Staines, who is the lead sponsor of the L3C legislation in Illinois, unfortunately could not be with us today because she is discharging grave constitutional responsibilities that we all hope to have soon resolved in Springfield. But we're very fortunate to have Jen join us to tell us about the status of L3C in Illinois. Jen previously had worked for the Environmental Law and Policy Center as a policy advocate focusing on renewable energy issues. So she's a kindred soul anyway. I should tell you, Senator Staines is a former chair of the Donors Forum. So there is some like-mindedness in the room. Jen earned her law degree from the University of Illinois Law School, and she has both undergraduate and graduate degrees in environmental science from the University of Illinois. While in law school, Jen worked as an intern on energy issues for soon-to-be Governor Pat Quinn. So, Jen, thank you so much for joining us. Very much appreciate you being here.
Great. Thank you so much, Mark. And just on behalf of Senator Staines, I really want to thank you all for the opportunity to update you on this legislation. Of course, she's very sorry she couldn't be here. We have, as Mark talked about, Senator Staines really has an interest in this piece of legislation. She began as state senator in February of last year, so she's a brand new state senator. But, coming as one of our staff members, I have to say she's already been fairly influential. She's been very involved with the selection of the new Senate president and with rules reform in the Senate. So she's looking forward to being the chief co-sponsor of this bill. We've already drafted the legislation for the for the L3C. And we don't have a bill number yet. I had hoped to have a bill number by today. The legislation that we've drafted is modeled off of Vermont statute, and we felt that that was very good to keep everything uniform and in line with states that have already passed legislation. And it just basically goes through those same purposes that that Mark talked about. That it has to significantly further educational or charitable purposes, and that no significant purpose of the company is production of income. And it provides for, the creation and the cessation of the L3C. So one of the things, as we're going through the constitutional duty that Senator Staines is partaking in right now, when that is over, which estimates are a couple of weeks, the normal legislative session will begin. And I'm not sure how familiar everybody here is with the normal legislative session, but it usually runs until mid-May, sometimes later. And we're hoping that we can bring this bill into committee late February, early March, and really get going on it. So we definitely, anybody who's involved with this, we definitely can very much use your support in contacting your legislators and getting them involved. Senator Staines today learned that Senator Dave Kaler from Peoria is very interested in being another chief co-sponsor of it. And that we met with there's two state agencies that have to do with nonprofits that we're working to get the support of. One is the Secretary of State's office, and the other is the Attorney General's office. And so far in our meeting with the Secretary of State's office today, they're, very much in favor of it. So, we're looking forward to working with them to be able to pass this bill. And of course, looking forward to working with all of you to get this done. So, thank you very much. Any questions? Go ahead.
This is really fascinating, so thank you for presenting this, both of you. I'm wondering what the implications are for current nonprofits that may be interested in, if